Thank you for watching Voices of the Bar, where the legal world speaks. We ask you to subscribe. Don't watch minus subscribing, share and like our videos. Today I want to go to constitutional history and I want to discuss the case of R versus Amkeyo. This is a case that happened in 1917 and it's a locus classicus case when discussing customary law, when discussing the concepts of repugnancy, which of course we shall see as we discuss the Order in Council in future. So let's now go to the case of R versus Amkeyo. Now this case, Amkeyo was accused, he's the accused in this case. He was accused for stolen property, and specifically the stolen property, this was the hide of course of a heifer. So, and he had told his wife to take it out. Oh, sorry, his wife had gone to the village. They had gotten married. Amkeyo and the wife Nyadobi, the wife was called Nyadobi. They were married, and of course, when you stay home, when you're married with your wife, time come when they want to go and see their parents. So Nyadobi decides to go and visit home. So when he comes back, he finds a hide at home. So Amkeyo gives her instructions: take it out, dry, and then bring it. They would keep it under the bed. So so they were eventually caught. And now when they were caught, of course we have an issue at court. So at court, Nyadobi, the wife of Amkeyo, was presented as a witness against the husband. But you know, in the English law or in the law, it's clear that your wife cannot give evidence against you. If you're married, the evidence from your wife is not admissible in court. That evidence cannot be allowed in court. Of course, when we discuss later in criminal law, we shall meet things like accessory after the fact, and then the analogy that when you get married, 1 plus 1 in marriage is 1. So you become one person. That is their joy. So you can, your wife cannot testify against you. And now this was the position. This was the position of Amkeyo. Amkeyo was telling court, look here, this is my wife, and if you are married, your wife cannot testify against you. It is illegal for this honorable court to allow my wife to come and testify against me. So this was the position of Amkeyo. So the contestation now is, can, in a marriage setting, in African setting, the way our marriage is, can a wife testify against their husband? In the English law, it was never allowed. At the time, we were looking at the evidence, the Indian Evidence Act, I think section 3, because I stand to be getting a section, but it was the Indian Evidence Act that a woman cannot testify against his husband if those two are legally married. But Judge Hamilton had this to say. For him, he said that for us in Africa, what we consider marriage is not marriage. He termed it, quote me, I quote this, he termed it, what we consider as marriage is mere wife purchase. That for us, we purchase the women. He goes ahead and says, Judge Hamilton, he says that your marriage, a woman is not a free contracting party. A woman does not contract freely. The African marriage. And then he says that because of that, there is no freeness. So our marriage is characterized with the bride price. To him, Judge Hamilton, that bride price means that you have sold your wife, your daughter. So this man has bought in the process of negotiation, that the wife's ideas are not taken. The father of the woman, the parents, negotiate with the man. So to him, what we considered marriage in the African setting was never marriage. It was termed as mere wife purchase. Now, after advancing those reasons, he now suggested that the wife of Amkeyo, Nyadobi, can testify against his husband, because what they consider, for us here, we consider to be marriage, is not marriage. So in this case, the wife was accepted to give evidence against the husband. Let's pause a bit from there. The question is, why am I quoting the Indian Evidence Act? These are things we are going to cover in future when we discuss the order in council and then the reception clause, when we received the English law, 11th August 1902, when we received the English law. So because we had received the English law, so among them was the Evidence Act from India that we were using at the time. So that's why we are quoting the Indian Evidence Act. Now, Judge Hamilton stated that for us, what we consider to be marriage is not marriage, is below standard, and therefore Nyadobi, the wife of Amkeyo, was allowed to testify against Amkeyo. And when she testified against the husband, then Amkeyo was convicted, was, I think, given strokes, and then I think 80 shillings that was charged of. Now, that case, we shall discuss it further when we are discussing repugnancy. Actually, if you check on Law School Med Easy, we have a video that we termed the repugnance clause. Under that video, we have extensively discussed the case of R versus Amkeyo, also leading the case to the principle of that case. Of course, now, that case established that our culture, our customs were repugnant, were inconsistent, were incompatible to the doctrines of natural science, consciousness, natural justice, consciousness, and morality. That our culture is below standard, was repugnant, was inconsistent to the doctrines of natural justice, consciousness, and morality. These are the three principles. That our culture, depending on the type of marriage we carry, our marriage was repugnant to the principles of natural justice, consciousness, and morality. So, I want to thank you so much for watching Voices of the Bar, where the legal world speaks. We ask you to subscribe, to share, and like our videos. Thank you so much. Until next time, see you, subscribe, share, like our videos. We also have another channel that is Law School Made Easy, where you don't get a video on Voices of the Bar. Kindly cross and check it out on Law School Made Easy. Thank you so much. Until next time, cheers.